So Sri Parthasarthi Misra, board member of Amnia Corporation US and former CHRM Tata Steel OMQ division. Dr. Tapas K. Panda, CLS, Welfare Commissioner, Government of India, Bhubaneswar, and former Deputy Chief Labour Commissioner, Central Kolkata. I extend a warm welcome to all of you to this very important session on demystifying new labour code. On behalf of the chamber, I cordially welcome Sri Parthasarthi Misra and Sri Panda. Dr. Panda was the committee member constituted by Government of India on labour reforms on IT portal, simplification and amalgamation of labour legislations and rules. Dr. Panda is the recipient of Bharat Gaurav Samman in 2017, conferred by the World Human Rights Protection Association, India chapter, for his work in the field of labour. Thank you so much, Sri Misra and Dr. Panda, for accepting our request and sparing your valuable time with us. I'm sure the participants will gain critical insights on the new labour codes and the implication from our experts today. In a historical move with an objective to consolidate, rationalize, and simplify complex labour laws, 29 labour laws are replaced with the 4 new labour codes dealing with wages, social security, industrial relations, and occupational safety. Labour being in the concurrent list, all states need to ratify the rules. Labour codes to ensure creation of one India and one law, reducing the number of laws with often conflicting definition of terms and provisions to only 4 codes. The revised provisions under the new labour codes are expected to cause enormous impact on both the organizations and the workforce. The industry needs to comprehend how new labour codes will improve the ease of doing business and what measures they need to take to align the practices to these changed laws. The Code on Wages 2019, as well as the Code on Social Security 2020, introduced a standardized definition of wages. Wages now include all types of remuneration, including basic pay, DNS allowance, and retaining allowance applicable to all prospective social security schemes. The wage code also mandates a rise in employer and employee contributions to EPF. Gratuity liabilities are expected to increase. Companies will now have to clear all employee dues, including salaries, leave encashments, reimbursements, etc., within 2 days of the last working day of the employee, from the current 45 to 60 days after employee exit. Equal Remuneration Act being now subsumed in the Code of Wages, it clearly prohibits discrimination in remuneration on grounds of gender on work done of similar nature and recruitment of employees for work of similar nature. The replacement of the term men and women under the old Act with the term gender is a welcome move. The code will help facilitate bridging the gender pay gap across all sectors. A clear definition of the term discrimination and recognition of the work of equal value will help further strengthen the objectives of equity that the code seeks to attain. EPF and gratuity would now be applicable to both organized and unorganized sectors. The Employee Provident Fund and gratuity contributions are set to rise under the Wage Code and the SS Code. Waiving the pre-existing cap of 5 years of service, the code permits a 1-year service for employees to collect gratuities. The key to success, however, would be to ensure that a firm start date is provided. This will enable organizations to work as per defined project milestones. Employees and employers are both keenly waiting for the implementation of this labor code. Given that this needs to be implemented pan-India, Government of India needs to have in-depth consultations for earliest implementations, either code by code or integrated. And today's session is an effort in that direction and is meant to throw light on the 4 new labor codes that we just said. And with these few words, I now invite Sri Misra and Dr. Panda to take us through the new labor codes and its implication on trade and industry. Thank you all, and over to you, Mr. Misra and Dr. Panda. Looking forward to have your insights.
And Dr. Panda, your video is now fine. We can see you.
Yeah, there is some problem actually. Yeah, Mr. Saab, first you have to start.
So, Mr. Mishra, you have to unmute.
Yes.
Mr. Mishra, you're muted.
With this video on off not appearing, so you get stressed up, right? So mute unmute also becomes an issue. Now I think you are able to hear me now.
Yeah.
Yeah. So thanks everybody, all learned people. So today we are glad that we are with a very learned expert with us, Dr. Panda, because when I was told by the agency and Dr. Saugat called me and we discussed many things regarding the new code. So that was the time what I was thinking, that we are going to discuss about a very trivial thing which has not yet been implemented even, right? So when you are going to discuss certain things which has not been there and which is not also implemented, then there you have the issue of going back into the history and find out what really exactly happened there. And then I was thinking that I thought that when you release a film nowadays, Mumbai film, so at the time of releasing the film, you bring in all the script writers, heroes, heroines, and all those people. They come and start, promoting the film. Then I thought, why not to bring in someone who, in the background, who has written the script of this film, and many times the script writers are.
I'm not involved in all parts. Small parts have been there.
I know that, but you have seen things happening. You have seen things happening because when we discuss it on the basis of the PPTs or the basis of the facts or maybe the gazette notification, whatever is there available with us. But when we have somebody like Dr. Panda, then we go ahead with certain intricacies. When you go back into the history, understanding what went when and how to take it forward and what happened exactly at that point of time. Secondly, I would like to also have a disclaimer here. So whatever we are going to discuss today, so we are not going to discuss on behalf of the company we are from. Like I'm not going to talk on behalf of my company. Whatever I say, that's my own version. So that is not the version of my company. I hope and Dr. Panda also, whatever he's going to say today, he's not going to talk what the government is saying. Because at certain point of time, you are glued to the code of ethics, or there are certain rules and regulations when you are working somewhere. So whatever we will be discussing, so that would be purely personal, and it should not be quoted that this is what the government of India says and maybe my company it says. Then typically I was going through a very nice poem written by Samuel Foss. Samuel Foss is a very historical poet. In the year 1895, he had written a poem, and the name of the poem was The Calf Path. The Calf Path. Today while coming for the program, I was just thinking about the poem, and the poem Samuel writes this way: once a calf got distracted from the herd, and it went on jumping and trotting in the jungle. So while jumping and trotting, he crossed the jungle and went to the other side of the jungle. And while doing that, somehow because of the mark of its hoof, there was a small lane which got created. So some sheep, they followed the hoofing mark of the calf and they started crossing the forest, and they also landed up at the other side of the forest. Then some wolves, those who are following those sheep, they also started following, and finally it so happened that hoofing mark of the calf, it became a small lane, and since the calf was going helter and skelter, so that lane also became helter and skelter. So after some time, few days, the businessmen from one side of the jungle to go to the other side, they also followed the same calf path, and finally it so happened that became a small village. The villagers started constructing it as a road. That road became a big road, and that became a municipality. And finally, one fine morning, one engineer started arguing and started shouting at people, who is that architect or who is the designer who designed this road, which is so much, helter and skelter. It is not a straight road. So nobody was knowing that it is the calf who was the architect of that road. It is the calf who designed that road. So it is the same thing which is applicable now. All these 29 laws, what we were discussing today, which was mentioned in the beginning at the time of the introduction to the program, all those laws started coming up again and again, one after another, getting added up. So one law comes, then to get rid of it, there are certain issues, we go on adding certain other things. So likewise, things got piled up. So factories, the mines, the BD cigar, and likewise, so many things started connecting after each other. So that became a very, very big jungle. And finally, someone came and started asking, who did that? Why there are so many laws? Why can't that be simplified? Why can't there be a straight road? And that is how I think the straight road concept, it came. I go back again into the history when the first National Commission of Labor, it was formed. I think it is the mid-60s when it was formed. And after 33 years, the second National Commission was formed. So it was a very long gap. In between, nobody thought about it also, if certain changes are required for this country, because the country was very rapidly changing and things were also changing in the labor front and in the legal front also quite rapidly. So the second commission, it was formed in the year 1999.
1999.
And 1999 commission, they submitted the report in the year 2002 when Honorable Prime Minister, that time Atal Bihari Vajpayee was the Prime Minister. So that was the time when the thought process started, how to change it, how to bring in certain things. But unfortunately, nothing happened after 2004. So 2004 to 2014, again, there was a lull, there was a void, nothing happened. But again, after 2014, lots of thought process was brought in. How to do it, how to take it forward, how to liberalize it, because there are so many laws. So suppose you go for the definition of the wages, you definition of the workmen. So different laws speak different things. So in between, the legal experts and the labor specialists, they were the malamal people, whereas all the labor people and all the people, those were the owner of the company, they were finding it so difficult running around the legal experts, running around the advocates, running around the court of law. So that is how the thing started. And when the 2014, the new government came in, they said, Sabka Saath, Sabka Vikas, Sabka Vishwas. And that is the time when they started saying, even the Prime Minister of India, he also said, let's start merging. So it is because many times people say that 29 laws merged into 4 codes. It is not, because what I understand, it is not the merger of the 29 laws. Rather, people started thinking, the leaders started thinking in a different way, how to bring in a different concept altogether, keeping in mind where the country is standing now, keeping in mind the developmental aspects where the company is going to move forward right now. I think that is how there is a total reorganization. So there's a total merger of these laws, and finally now all these codes which came into picture. So again, code also is taking time. As usual in India, things takes time, because now since it's a dual subject, both the central and the state, so state also has to agree. So there are many states, those who are agreeing to that. There are many states, they are under the process, things are under the process. And there are many states, they are saying that, yes, we agree in 1 and 2, we don't agree 2 and 3. So even though the wage code was passed in 2019 and 2020, all other codes were passed, even after 2 years, it is yet to be implemented. And I think last 1st of July 2022, I think it was decided that things should be implemented, but that also couldn't be done. And I think still there are discussions going on and things are happening. So with this context note, I would request Dr. Panda to take us through, because he has seen how things were happening. Because 15 to 17, when all those concept notes were on the web for the people to go through, people to come up with their reactions, people to come up with their suggestions I think he has seen those things right from those days. And I request Dr. Panda, please take us through the process while it was happening.
Thank you. Good afternoon, all dignitaries, my friends and colleagues. Actually, before I start, let me say again, government servant is always a government servant. Disclaimer is for you, not for me. I am bound in conduct rules. So what you say tomorrow, I'll be there in the dark, and your disclaimer will not come to my rescue. Okay. So I'll not go to the controversial or intricacies or don'ts part two, all this. I'll speak about do's part one, and I'll say historically the developments occurred in Indian industrial scenario so that we can reach to a point where we can say what was necessitated and what happened and how it will happen. There are three phases. So when you go to First Factories Act 1881, then 1911, then 1921, you go the first major Indian labor law came after ILO was formed in 1919. And it was EC Act 1923, Workmen's Compensation Act 3, then now it is EC Act in 2008. Then if you come Trade Unions Act 1926, then 36 payment wages, then so on. If you see the growth of industrial labor laws, first it was to protect from zamindars, from textile owners in mines, in railways, in plantations that workers are exploited. There are no regulated working hours, no wage. So government thought to, rather British government thought to protect them. And over the years, the laws first were basically welfare, then socialist, then little bit of welfare, then now it will be turned to capitalistic. This is the twist and turns of the events of labor laws over last maybe I think 100 years. Then I will say if you go to labor laws, I have said in so many forums, and I have no doubt in rather telling, no hesitation in telling in a public forum that actually, to be very honest, the existing labor law is never archaic one, is never against the employer too. It is rather pro-employer, and many people do not know what is labor law. It is a secondary business for many people who do the primary business in the mask. They do not know depth of labor law interpretations. And in fact, I have attended few of the ILO workshops where I have told, if you do not know labor law, it is pro-employer. If you know labor law, it is rather is, if you do not know labor law, if it is anti-employer. If you know labor law, it is pro-employer. And I have given, I think I can give 10 to 20 examples. So to start with, a law is applicable to 120. Why not 19? That is utilized, misutilized. 10, why not 9? 5, why not 4? MW Act 5, BSW Act 10, ESA bonus 20, gratuity 20, contract labor 20, establishment 20. So factories 20. So there are so many workmen selling are there, and the biggest part of it that many of the laws, if you see all my friends, where was the existence of service sector in all these laws over the decades? If you see, service sector had no existence in all these laws. If you see particularly Payment Wages Act enacted in 1936, it is applicable to A to G. If you go through deeply to A to G, it is applicable to industrial establishment. What is industrial establishment? If you see again, it is silent about the service sector. 1. 2, if you see the service sector in A to G, you'll find only your transmission and ATS. 2 are there. It is later amended. So what about bank? What about other sectors? People do not know, but people go and inspect, and other person gives the compliance also. So there are gray areas. 1, 2, the wage ceiling was never revised from 500 to, I think, in 1982 to 2000, I think, 5, when Payment Wages Act was enacted. It never was 23 years. The wage ceiling again became 1600 last. Then it came to, of course, 1500, then 15,000, 18,000, then 24,000. What about people getting 23,000? 1, 2. If your minimum is high skilled, is 24,000. And if your wage ceiling is 24,000, the applicability part, it is not commensurate, it is not proper. So many where And if you see the bonus act, the applicability, the calculations, if you see there is no schedule employment. So 7,000, whichever is higher when you interpret, you cannot interpret. And the most important part, which I am saying, apart from industrial establishment, applicability of PW Act, the Mini Uses Act. The Mini Uses Act, if you see the applicability, if you see the basic law, it is applicable to whom? It is applicable to starts with in a schedule employment. In a schedule employment, one, notified two, then question of many wages will come. If you see schedule employment in many areas of central government, out of 45, 36 are mines and 9 are non-mines. So again, the schedule employment concept is, again, in many states, they have got elaborated schedule employment, and many wages is equally applicable. But when you see central sphere, the many wages concept is sometimes fall in gray areas. So if you see the Wesseling one, industrial establishment, if you go to again, Standing Order Act, it is industrial establishment. I have asked, I think, many big forum, what is industrial establishment in Standing Order Act? Many people do not know whether Standing Order Act is applicable to IT sector. One, applicable to Dukan. Two, applicable to large chain stores, retails, banks, insurances. Nobody can say, because it's the 1946 law. In 1946 law, question of service sector was missing. 1948 MW Act, service sector kahan tha? 36 service sector kahan tha? So all these things, they are benefiting, rather they are benefiting the service sector in a major way, except Substance Establishment Act. There is no major law which is protecting the interest of work employees, rather in substance establishment, and particularly trades community which are running the various entrepreneurship. So if you come to the present existence, suppose I was there, the biggest important part which we did, actually I was committee member for one, forms, two, rules for registers. So if you find we had around registers, we had around maybe 90, 100 registers, we made it A, B, C, D, E. So we squeezed these registers into 5 major areas, so that the question of another 90 registers could be done away with. Then we want to forms, when again forms are 90 to 100 forms, we squeezed 26 forms. So these are the basic important areas. And as rightly Path said, the most important part, which I think we are now touching, the confusion and overlapping provision and rather contradictory provisions, like what he said, OS. I'll always say the 5, if you go to report of the Second National Commission on Labour, it had suggested that we should bring umbrella legislations, one, for integrating the labor laws. That time it was supposed to be 44 legislations. And second, we will try to streamline 4 important, 5 important parts. 1, in the employer; 2, employee; 3, establishment; 4, wages. So these are the things: employer, employee, wages, establishment. These are the things to appropriate government, of course, most important, appropriate government. So these things they wanted to integrate, they wanted to rather assimilate and fall into lines. Because if you see the appropriate government as on date, in industrial dispute, in contract labor, in bonus, the same appropriate government concept goes. But if I grant license on contract labor, if you see to wage laws, wage law, I think in IR law, wage law, if you see in existing scenario, they are there. They don't go side by side. I grant license for sector A, but minimum wages, when interpretation comes, it goes to state government. So I've been asked many times that why the central wages is not applicable to some of the areas, despite you are granting license. People come and argue with me, sir, unions come and argue with me, sir, you are granting license and you are taking industrial disputes, but when it comes to wages, why the state government wages are paid? So these are the important areas: the streamlining of appropriate government, 1, ways 2, the employee 3, somewhere it is employee 1, somewhere it is worker, somewhere it is employed person. So somewhere the employee is different, varying. So there has to be consensus in drawing inferences in these concepts. So appropriate government were again a very, very contradictory factors. So these particular terms and concepts have been integrated in the new labor codes. And I'll start now the present, what we have done. As everybody knows, now this present law is largely applicable to service sector in totality, where the burden on implementation and enforcement of wage law will be everybody, with added responsibility, scheduled employment being done away with. There will be no scheduled employment. So scheduled employment sometimes is hindrances, because this is not a scheduled employment, so many wages may not be applicable. One most important area. Second, the industrial establishment, the basic rather interpretation of A to G will not be there to because again, if you see the industrial establishment in contract labor in Payment Wages Act, you'll find the industrial establishment definition in Industrial Dispute Act in definition is interestingly very different from Chapter 5 and 5. I have asked, I think, this in a major forum. People have failed to properly answer me how many types industrial establishment there in various level laws. So people have become absolutely confused. The other day, in fact, I was asking, I was an expert for interview of a very senior person in a Maharatna company. I asked what is the statutory backing to trade union recognition? Then somebody said Trade Union Act. Then this is exactly a matter of, again, another gray area and concern. How the trade union recognition multiplicity to curb the multiplicity, how you can make a single union recognized. Many states, they have framed law like Odisha, Bengal, like Kerala, but many other states, more than 20, have not framed any legislations. In central sphere, when I asked in that interview that a very senior level position with 24 years of experience, he doesn't know in central, but he has participated in his CV, has written, I have participated in trade union secret ballot election. In no secret ballot election, but he doesn't know the source. So what is that? Code of discipline. How code of discipline is evolved? What is the industrial truce resolution? What is Indian Labour Conference recommendation 1962? Then what is the scope of law? What Supreme Court said on secret ballot election, on code of discipline, not what Odisha High Court said. So these things led to, in fact, in Odisha High Court has gone one step ahead when it wrote in last sentence, the central government is hereby advised to frame legislations to bring the trade union election within the ambit of law. It is recommended, my case only, this is my case, is reported RLC versus, I think, Steel Employees Association. It's a very important case. It's a fantastic judgment where it has in-depth analyzed the scope of trade union election. So now when this regenerative code comes, in IR code you will find there is uniformity in industrial disputes 1, appropriate government 2, in wage 3, and of course the chapter 5A, 5B, they have streamlined to 300 chapter 5B, particularly in a special chapter. And most importantly, they have made your standing order applicable to 300, and they have removed the industrial establishment embargo criteria. They have enlarged it. So this is a very interesting concept, and they have brought fixed term employment, which is a very new concept. Of course, it was there. Fixed term employment in standing order, it came first, came in standing order in 2004, then repealed in 7, then came in 14, then added in 18. First, it was added in for textile sector. I had the argument with the concerned officer in the ministry, why you are bringing something which is meant for only one sector? So then he said, this is a mistake. Everybody will try to take benefit of it. So the fixed term employment is a very important concept which has been brought in. Then what is not a contract labor? It's very interesting case.
One point, Dr. Panda, I would like to just ask related to the wage code. There is a floor wage concept which has been introduced in the wage code. And the floor wage has different geography. They will be having floor wage will be similar for the entire country, but different geographical region. They will be having different minimum wages criteria.
I could know once the moment you said one word, now or 10 words, the sentences are
So
redundant.
how it is practically going to be done? And second, every
Listen,
5 years it is going to be revised.
again. First, listen to me. Once you said floor will, then floor is mine.
Yeah.
What you are adding is redundant. Once you say floor in, because you
Yeah.
know one word, I know the background, I know the scenario.
Right.
Floor, to be very frank, when I was in Odisha government on deputation, sometimes in 2010, this issue came to me. In this sense, every year, state government, central government issues administrative circular for fixing the, rather communicating the floorways. Floorways, if you see, to be very frank, is a, you can say in thumb rule, it is an average of wages of various states, and there is a remarkable difference between agricultural wages and the wages of other sectors. There is a time when the agricultural wages 125, the minimum wages of a state was 200, 75 difference. So this, because of this agricultural wages and minimum wages and wages of Nagaland and wages of Maharashtra and Punjab and central government. So all this added together, it came out that national floor wage is X. But what I am saying, don't confuse national floor wage with the minimum wages, how it is fixed. Please remember, minimum is fixed. 1, 2 on the capacity of employer to pay, 2 geographical area, 3 production and productivity, 4 the skill output. So there are actually criteria fixed in the 1957 Indian Labour Conference. Then I add, what I add? Then standard vacuum case, standard capacity, the minimum security to be added. So that was, after that, then came newspaper establishment case, 25% you add. Then 20% Raptoka case in 1992 Raptoka case, where they said, with security, little bit of luxury is important. In 25, if the electrical, gas, food supply, उसका बाद थोड़ा सा ऐड करो, जो 25 का जो जजमेंट स्टैंडर्ड वैक्यूम न्यूज़पेपर एस्टेब्लिशमेंट दोनों केस आगे पीछे आया, लेकिन 92 में they added luxury. What I am saying, the Minimum Advisory Board of the state is a statute, is a board having the backing of the statute. 1, there the representative employer are there, 1, the representative employees are 2, and government machinery is there. They make the brainstorming and they decide, and when they decide, the various factors go to the floor and they discuss. And likewise, the central government also has the Minimum Advisory Board. In fact, recently I was part of Central Export Committee on Minimum Advisory Board when they discussed many surveys, about 4 to 5 surveys were discussed, and I was part of it. I was rather getting enlightened. So this is the Minimum Advisory Board has decided on various aspects are left best to the experts along with Supreme Court guideline in 2 cardinal judgments. So this whole bouquet is the minimum wages. Then comes your fair wage, then the living wage. Living wage is the part of fair wage, and living wage is a part of the collective bargaining. But the floor wage, what you are saying, is definitely floor wage which government thinks, government decided actually 176 when initially did, there is a lot of uproar. The person who did it, I know him in person, in fact, we had a lot of discussion and died. He said, I am in now not in my right frame of mind because many people are not understanding what I am trying to communicate. He said it cannot be. First of all, your wages cannot be less than the wages notified by the state. Section 9, a capital A is there, 1. And minimum wages cannot be less than the minimum wages what it is. It's fundamental question of law. Then question of floor wages. Floor wages is overall concept. And the floor wages, government, I think recently Honorable Minister has said that we are also reviewing it. What they said that we are also reviewing it. So I should not go into comments discussing on the policies of government as government servant. I am not supposed to discuss on the gray areas or controversial or policy areas of the government.
Fine.
The government has got expert people for it. So that is how this is very important. That whom, as you know, whenever Prime Minister, when he said while introducing, I think in his inaugural speech of 2019, he said, I am going to bring 40 workers in unorganized sector by simplifying the employee. Employee includes the managerial function. 1, 2. They remove 24,000 wage selling. There will be no wage selling, and they include managerial function. Now question comes, AD of a company is an employee. How he will seek his grievance redressed in wage code? Question of now the, I think the employers, the entrepreneurs, the various professional bodies, the how to address, how to visualize, because in COVID-19 period, central government received, I was part of the control room, and my control room, I think, got second best officers award in the country. That's another issue. We received every day around 200 to 300 calls. And for information, out of 200 to 300 calls, 250 belong to state government, 50 or 60 or 70 belong to central government. So out of 250, we found interestingly 150 belong to the executives, the bank, the insurance, the IT, the telecommunication, the many traders, Uber, Ola, there are endless complaints. There, if you really go to interpret the wage selling one, the definition of employee 2, the embargo factor 3, they may not get any relief. So now the new era, when your employee definition is so vast, so he will come and file a complaint. And industry should now imagine a general manager going to make a complaint of something. If some allowances are not paid, that is a part of wage. Then how industry is prepared to address that? What is the, if you see again, the GRC, WC, it doesn't speak out to employee. If you see the works committee, new IR code, if you see grievance redressal committee, it doesn't speak out employee, it speaks out worker. If you see wage law, exactly, wage law, the 9 parts are employee and 16 parts are for workers. Somebody asked me whether there is a minimum wages for employee. Then I said, if you see the law from here, from the 11th floor, 11th story, it is yes. If you see from the ground floor with a microscope, no. So this is industry is going to face, because they will have to have clarity. 1, 2, the second, as Dr. Mishra said me, that the wage part is not fallout of the wage code as promulgated. I think many of you might be aware, when contract labor is now, who is not a contract labor, they said regularly employed, whose service is governed by falana, that terms and conditions of increment, social security is protected, is not a contract labor. This came from where? This came from the Basant Mahanti case, Odisha High Court case. If somebody is employed in the regular role of the employer, then he is not a contract labor. Way back 1996, but it came. Then Arvind Construction case, 1992. Both the cases here and there. First is Arvind Construction, 1992. Then 1995-96, this Basant Mahanti case. Both cases gave a different dimensions. If I am regularly employing a person, he may not be contract labor because he is the regular role. Now it is part of the law. Then if it is part of the law, how you are going to interpret? Because when you are having a contract labor and contractor says, I will not take license. Why? Because he is not a contract labor. Now, who will decide he is a contract labor or not? Who is decide it is a fixed term employment now? How to interpret? What is the standard of contracts? What is the standard of instruments which will distinguish from regular employer to fixed term employment? Because both these things lead, if you see the present section 200BB of ID Act, you will find very interestingly, non-renewal of contract is not an act of retrenchment. It was there in the law, but non-renewal contract 200B now integrated with the fixed term employment. Now, how industry will take benefit of that? How to interpret language in then ways, as you know, the Provident Fund authorities and the employer, they had a lot of fight in calculations. I have been told many times that आपने क्यों एम्प्लॉयर को दंडा नहीं दे रहे हो? 40,000 सैलरी में 400 रुपया फिक्स डिपॉजिट मैंने पे बेसिक है. बहुत बार ऐसा हुआ है. I have told to my friends, मेरा काम मिनिमम वेजेस देखना है, मेरा काम बेसिक नहीं देखना. I have to interpret minimum wages. What is a wage under the Minimum Wages Act? If it includes A, B, C, D, E, I will see A, B, C, D. If it does not include F, G, H, I, J, I will exclude that. But if A to G is minimum wages. I will say that. But what you are saying, A is 400 out of 40,000 salary. So my intake for the provident fund is 40 rupees. So it led to Supreme Court in how many cases? 146 cases. And what Supreme Court said in 2017, club together the allowances which are part of your daily life, living allowances, which are directly attributed to your day-to-day life, will be part of the wages for purpose of calculation. Now government thought, if I do not keep a clarity, then everything will be part of life, living allowance, living wages.
That's how the 50% thing crumbled.
That is how they thought that let us do. सुप्रीम कोर्ट को थोड़ा सलाम करते हैं, प्रोविडेंट फंड को सलाम करते हैं, वर्कर को सलाम करते हैं, एम्प्लॉयर को सलाम करते हैं, then this will give. But yes, that calculation, that 50% more than the basic, over and above 50% will be added. If it's 20,000 basic, 20,000 allowance, then 50% 10,000, 10,000 will be added to 20,000, 20 plus 10 is 30,000 is the calculation, and 15% will be not beyond that, will be in kind, because kind again a very controversial area. मैं खाना देता हूँ 10,000 से 6,000 लोग काट देते थे. In particular, food, services, contract labor, construction. So now kind, at least kind had a thumb rule. Kind has a picture. Kind was faceless. Now kind has a picture. So what I am now saying the industry is that when it comes to the implementation part, the preparedness for predicting the scenario beyond 5 years. Beyond 5 years, predicting 5 years is a roadmap. Roadmap means you cannot mechanically add to your stable. Everybody is fixed. Everybody who is not a contract labor, because that may lead down the line to issue of regularization by the trade union as an industrial dispute. Now you see the regularization as on date in our office or in state government office, you will find 6 out of 10 disputes are on regularization. Means we want to regular employment. Regular employment आएगा कहाँ? What is the disparity between the regular employment salary structure regular? Because in LTS, what we have done in long-term settlement or long-term negotiations, we have somehow over the decades taken away the skyrocketing the wage hikes in public sector and many of the private sectors. And we have forgotten the minimum part of the daily wage. When we have fixed the regular wages of regular employee, suppose you are giving 7,000 and when the minimum wages is 12,000, then we are forgetting the gaps one, leading to industrial unrest, jhamela, violence, down. So now things are come as per new code. You have to keep somewhere a daily wage, fixed term employment and regular. Because fixed term employment is a person who doesn't have any right for bargaining. मैं fixed कर दिया, आपको लेना है तो लो, नहीं आपको किसको? So there 3 things will be there. But again, at the end of the day, after you keep fixed term employment for 2-3 years, can you put fixed term employment for 15 years? What is the stature? You have to predict. I went to one industry for inspection, one establishment, maybe about 8-9 years back. I found in whole state the 5 people are executives from the role of the employer, main employer. But interestingly, 52, including executives, around 30 or 35 are in outsourced role. And the best of us, they do not know. They do not know. Only 5 are from ex-establishment. 30-35 are from the outsourced role in Chennai. Then 10 or 15 are again outsourced in non-executive category. Then these people What is their status? They have been interviewed under the banner of principal employer. They have been given hope they will be employed with the principal employer. They have given place of posting at principal employer. But the salary is transferred online by the vendor in fixed term to his account. So when his job comes to an end, he doesn't know where to file case, and he comes straight away with the principal employer because there is no transparency. When it goes to court, then principal employer finds it to be backward foot. Because it thought perhaps by giving to vendor, I am doing a very intelligent thing. But by not keeping the things transparent, that is how now the total compliance of wage register, particularly attendance, it will be all in electronic mode. 1, 2, it can be visible to me, to vendor, to principal employer. I won't be surprised if it can be visible to employee also in due course.
Now, coming to the payment of wages, when the government says now, or the rule has been made that it has to be through bank check or bank credit. What about the those are organized sector? It's fine, but those who are
I am not here to answer the critical questions on somewhere. I am not here. Ask the government. I am the government. I know your answers very clearly.
Okay.
Come to my office, have a cup of tea, we'll have 100%. Not in this social forum.
Okay.
But one thing. I'll tell from my experience. When it was introduced in 2015, I was heading a region in somewhere. And it started with particularly one area with hardly 30% implementation. When I left in 19, it was almost, I'll be so happy to share, about 100% implementation. This is purely backward mine area. मैं आपको share कर रहा हूँ. And this is the best ever thing, because 2012 in a national seminar somewhere, I had told this thing. People are laughing at me. 2012 में मैंने भिलाई steel plant में बोला था, huge works of all senior officers. It is not possible. Then said that will be very important for two things. Gathering evidence that I am safe from 21.4.1. I am safe from prosecution 2. I am safe from calculation 3. I am safe from workman's compensation 4. I am safe from calculation of benefits and accruals. I am safe. So now that even I am a big champion right now for biometrics for the contract labor. I'm a big champion wherever I'm going. Why? When an accident occurs, you do not know who is actually getting the compensation. When the security identity of the person is compromised as a gate, when he dies, I found people have died from other states, and as migrant workers have died in accidents in other states. Principal employer was ready to disburse, but the principal employer had no detailed information. So this is a very important area, that this particularly electronic transactions one, and the payment by electronic mode to, yes, unorganized sector. I'll say what Dr. Mishra is saying, going to extreme interior, like one forest, salt pan, remote constructions, there will be a lot of it. Isliye government has kept some also buttons, and it is important for all of us, in fact, to seal that area, because Sardar le leta hai. In interested migrant workman, a migrant workman is hired through a third-party person. He doesn't know what he's getting. He takes him with a promise of 20,000, gives him 5,000. His journey allowance, he takes his advance for 5 months, he takes for 1 lakh. Journey allowance takes 20,000. He gives only 30,000. Monthly promise is 22,000. And large chunk of workers are exploited through this. So this existing code will seal many areas. And the license ones, is going to be once in 5 years. Like the question of running to government authorities for frequent license is minimum, not desirable. Then how to, only what my concern is how employer is going to implement down the line 5 years, and what employer has done for impact analysis. Impact analysis means with pre-existing, I was getting this advantage. Suppose central minimum was not applicable. I am in central government sphere in ID and contract labor, but I was giving state wages. Now I will give central wages because the definition has been uniform. Then I'll come to calculations. Then I'll go to EC. Then I'll go to provident fund. Then I'll go to who is not a contract labor, my liability for him. Who is a fixed term employment, my liability for him. Who will calculate and take care of? It is a full-time trained IR man's job. And the third-party consultant who was coming as a khatadar previously, and you are too happy to get a khatadar, they used to come and they were a hindrance between the employer and the authorities. And he used to say, "Sala corrupt hai, bahut paisa mangta hai." And he'll never allow you to meet. And whatever he says, he trust you. But now time has come, you will have a full person. He will directly impact you. That is how the inspector has become facilitator. He will demand, he will demand to know.
Coming to the SS code, that ESIC is now going to be extended to almost organized, unorganized, everybody.
Yes.
Now, don't you think it's going to be a really difficult task? Like you have a servant, a housemaid in your house, who is working for you.
No, I think you have to see the non-ceiling applicability ceiling. You have to see the 20. I think that the ceiling is there. That ceiling is there. Only actually, if you see the last 5 years, the coverable districts in ESI Act were less. But now in 5 years, government has gradually vastly extended the ESI. And ESI should be encouraged because of non-applicability of ESI, it gives direct, rather financial burden to the employer. It gives directly financial burden to the employer. And ESI, if you give and third party takes care of, because I have gone to ESI hospital with our team many times. I'm so happy when I go to ESI Joka hospital. It gives such a fantastic world-class tertiary hospital treatment with a bigger amount being insured. So that should be given. Yes, when you always, when you think of very, very interior sectors, initially there will be hiccup, but there will be 20 people ceiling, one, and there will be a machinery available there, and there will be, I think, full-fledged health facilities available, because ESI in Odisha government, I think it was one of the best scheme in this sense. We are paying every month at least 2 to 3 crore rupees sanction every month. So who was giving? Government was giving. So it's a good scheme. So the industry over the period, I think what they have done, they thought Labor Department is all about khata. Labor Department is like a game of cross and zero and cross. Now it's not like that. It is a full-fledged professional job. You need to have a trained IR person, a rather compliant person who is very thorough about. In fact, here now, if I say how many people have generated lien, how many people have rather submitted their return on lien, how many people have integrated the annual return in lien, how to do lien, and how many people are applying registration and amending the registration and applying the license and applying the renewal. And the industrial dispute, I think Samadhan portal, now it will be over the period, 2K is more now. Previously, it was only for 2 capital A. Now 2 capital K is, your job will be more important, my dear friends, because in Industrial Disputes Act, there is a provision. After the failure, the government was examining the dispute and referring to tribunal. Now, the government will not examine the dispute or refer, except in case of national tribunal, industrial dispute of all India importance. There is no scope that government will refer the dispute to national tribunal. In 99% cases, it will be agitated, and the moment it is failure, within 60 days, the union will go to tribunal. Now, the moment union goes to tribunal, there comes the unions, stroke, negotiating council, stroke, recognized union. This is not the program. I don't have time. Generally, I take classes one-to-one. I think this is a virtual media, is a fake media where you cannot connect, you cannot contact, you cannot communicate properly.
Yeah, that's true.
So eye contact, the interaction one-to-one is
Initially, the
much
plan
better
was
for
to
all.
be offline, but somehow
No, but any
someone
case,
said we'll go for online.
since many entrepreneurs are there in the NCCI sector, I will request them to be alert in the particularly new areas where they have been taken to. You are in mainland, now you will be taken to some new area, new islands. So in these new islands, you have to make homework now. And in homework, these khatadars will not come to rescue because they never read labor law. They only go for money, for licenses. When it comes to work, they come to us indirectly. Sir, thoda bata dijiye na. पैसा लेंगे आपसे, बुद्धि लेंगे हमसे. Many advocates I have found, they are not very, in West Bengal scenes are much better in this sense. Many advocates are very well read. They have got much inner in-depth knowledge about the labor laws. But still, I will say the basic interpretations are with the employer. He is supposed to know, even if he is an MBA grad, even if he is a technocrat, even if he is an IIT, IIM pass out. But fundamental law is always to you, because domestic inquiry you are supposed to know. Before firing, you are not supposed to know principles of domestic inquiry. The suspension, the Industrial Standing Order Act, contractor, whether he will do standing order or not. I asked in a big national conference, the contractor will take standing order certification or not. Now, why should he take? It is not an industrial establishment. No, it is an industrial establishment within an industrial establishment. And you should encourage. It is a Bible for streamlining the service condition of contract labor. You should encourage. Your contractor document should not write one line that he will follow all labor laws. No, it's a vague line. The contractor is required to comply following labor laws, and each component to be calculated in terms of money, and it should be reimbursed and complied before reimbursement. This includes split gratuity, split retrenchment. Many people are following. That is why they are facing less problem. But 99% nobody knows what is split retrenchment, split gratuity. Everybody knows 1 month notice do nikal do. I asked in a recent interview to somebody, what is the difference between dismissal, retrenchment and termination? Person with 23 years experience doesn't know the difference. He is going to general manager of a company. I was surprised the CMD was shocked. What I am saying, people do not know. Why you know? Because when the CMD asks, he goes to an advocate and gets a drafting and says, sir, ये मेरा draft है. मैं महान ज्ञानी हूँ. वही problem है. Borrow someone's mind. If he is competent, you are competent. If he is idiot, you are worse than idiot. So this particular, the implementation of 4 codes, I tell you, requires lot of brainstorming. अभी मैं कभी भी जाता हूँ, कभी मैं बोलता हूँ, आपने बच्चों को सेक्शन में बांटकर एग्जिस्टिंग लॉ और न्यू लॉ में फर्क होमवर्क किया है? You are waiting for the time to come. No, you should remain prepared. Why you should remain prepared? The moment it is implemented, you are prepared. But that time आप experiment जब करोगे, तो आधे आपका डूब जाओगे. You have to mentally remain prepared कि कल आता है, तो I have to prepare. Existing law क्या है? What is the change law? Where I am impacted? मुझे कहाँ impact in your Southern establishment model, Southern establishment central government has circulated. I do not know, many of them are aware or not. In our office, people come for a bargaining on national and festival holidays. Invariably, out of 10, 8 charter demand out of 10, you will find there is a one clause. But whose subject is this? Who is the competent authority? Who is the inspector? Who is the appropriate government? What is the bargaining scope? What is the enforcement scope? Nobody knows. Nobody knows. National and Festival Holidays Act is a state act. Who is the inspector? How many days are there? National holidays. Some states 4, some states 3. Who can tell when last time West Bengal incorporated May Day as a state national holiday? Why May Day is not a national holiday in many other states? Out of 30 states, maybe 22 states, they have not incorporated May Day as a national holiday. Who will do it? When you are a pan-India organization with entrepreneurship having a satellite branch at Bhopal, an officer goes for inspection, and you do not know what is the national holiday, what is the compliance, who is the inspector, who is the authority. I asked, in fact, somewhere again in another interview, 4 people, who is the competent authority to inspect your establishment under PW Act? He aram se said, sir, central government. Then I said, are you aware? Yes, sir. Then I said, what is the appropriate government under the central government on PW Act? It is Roma, a beautiful girl, Roma, railway, oil, mines, air transport, ATS. और नहीं है, हमारा पास कुछ नहीं है, ROMA है. अभी ROMA हो गया मतलब rest others comes to state government. Then if it comes to state government, I may grant license under ID Act, Contract Labor Act. I may be appropriate authority under Bonus Act. When it comes to PW Act, then comes another angle. Is the act really applicable if all the employees in the establishment are getting 24,000 more? 1/6. Nothing in this act is applicable. We do not know this. We start panicking. So these intricacies, employer will not know. They are not supposed to know all level laws. They are supposed to see the business and growth, marketing, technology. इनका एरिया अलग है. उनका पास जो एडवाइजर है वही प्रॉब्लम है. They have to know. They have to be thorough, line by line. As he is asking, you have one establishment in port area, remote private port area. You are operating a stevedore agency. Then what are the laws applicable there? As Parth is saying, ESI. How many people are there? ESI applicable hai ki nahi? All India you have 100. In say Dhamra port you have got 9. What will the applicability? What is the concept of applicability? If I put fixed term employment, what is the concept of applicability? If I put contract labor, what is the concept of applicability? If I put on regular role, what is the concept of applicability? So that is how my liability and my contractor's liability should be clearly worked out. There should be systematic homework. So this new code is an extremely fine challenge with lot of brainstorming. It's not bad. I again repeat it.
Lots of impact on the union activity also, because now the 7 persons coming together can form an union, right? But things are getting changed there also.
And there are a lot of changes. 10%. One important thing I think what they have added, they have given power to trade union to file prosecution against the employer. So this is a very sweeping powers. So this has to be again kept in mind. How the employer will handle that. And that in negotiating councils, if unions have got a diverse ideology in negotiating councils, suppose more than 51% single union is there is no controversy at all. It is a single union. But less than 51%, if I've got 20% above, so that is on 51%. If 3 unions are part of a negotiating council, one is looking towards Kashmir, one is looking towards Kanyakumari, one is looking towards Andaman. Then you are in negotiating council. Then somebody is sitting like Bill Clinton, somebody is simply like Joe Biden, and you are making bargain. The poor Parth is doing the negotiation on behalf of 3 world heads.
Yes.
And somebody is agreeing for 18%, other ones is saying negotiating council. Other one is saying no 18%, 19. It has to be 19.
So that's going to give a very
So
slippery.
that is how this is again a new challenge.
Hmm.
This is again a new challenge. How to, one has to be thorough. The present existing law, मैं आपको लिख कर देता हूँ. The present existing law is important to take mileage of the future law. If you do not know thoroughly the existing, say 6-7 laws, 7-8 laws are very important. बाकी बीड़ी सिगारेट टी एक्ट सी एक्ट है important है, problem नहीं है, but they are welfare legislation merged. So center welfare legislations, if you know mines and contract labor, is fine.
I think one
And your liability again, OSH code, as I'll supplement, your liability in OSH code are heavy. You have to give information on demand. You have to, if you don't give information, you will be prosecuted. You will have to tell your liabilities what you have complied. If you have not complied, you have to inform the inspector. So these are the new OSH challenges. The entire OSH Act has conferred a lot of challenges to the employer. Otherwise, it will be visited. Very important parts are there in license, in registration, in standing order. The deeming clauses are there. The deeming clauses are there.
I think that's what gentleman in the question answer is asking about the working hours, 12 hours working. So we Majumdar.
You see, Mujhe, if you ask me, people are confused without knowing the labor law. That is the whole tragedy of the country. If you do not know driving properly, you are asked to go for MIG testing. That is all happening. मुझे अगर आप पूछोगे 12 घंटा कहाँ मना है आज के दिन?
No, it's all
Because go to basic of law. हम लोग का क्या problem है? We don't go to ground floor, first floor. We are moving around, hovering around 5th floor. That is a tragedy of Indian labor laws. We do not know preamble. We do not know section 1 and 2. Ground floor, first floor hai. We are going to 5th floor and we are feeling the heat. आराम से पैदल चढ़कर जाओ, ऊपर जाओ, फिर देखो. If it is not an industry under section 2J, why you are worried about industrial dispute strike under 22? So basic is, what is the existing law? Spread over. What is spread over? 12 घंटा. What is 12 घंटा? 12 घंटा है. Now comes to me for deployment. 8 घंटा mandatory. Clause 1 9-hour minimum wage act में है. Overall restricted to 48 hours.
48 hours. Yes.
So 48 hours, if you see many public sectors, they have got 40 to 42 hours. In fact, recently, there is a case in my court in Calcutta. The 37 hours were revised to 42 hours, 40 hours. Only 3 घंटा बढ़ाया. There is huge chaos. जैसे थर्ड वर्ल्ड वॉर हो गया, भूकंप आ गया, इतना हंगामा हुआ. मैंने जब बेसिक कैलकुलेशन किया 37 आवर्स. मतलब आप लोग तो लकी हो, 48 आवर्स से 37 काम कर रहे हो. But to convince them, the management was not capable or properly communicating, did not know what is ILO convention, did not know what is the question of law, did not know what is the contemporary industry is doing. And I had to sometimes work like personal manager, like Mr. Mishra, as an authority. So people say, ये बिकाऊ है, दारू पीता है 5-star होटल में, इसलिए मैं जाता नहीं हूँ. I don't go to guest house, I don't go to 5-star hotel, I don't take your friendship request unless personally one-to-one घर में जाओ, बैठो, मस्ती करो. Why I am saying no, industry will immediately accuse, even you tell the fair things. So your knowledge will give you a protection. It's very important. आप spread over hours से 8 hours से 12 hours से आप कुछ भी कर सकते हो. 40 hours अभी भी इंडस्ट्री में है. मैंने खुद सेटलमेंट साइन किया है, एक ऑयल कंपनी का मार्केटिंग ऑफिस का 40 घंटा किया हूं. मैंने 42 घंटा का साइन किया हूं. क्या मना है? आप बोलो कि मैं स्प्रेड ओवर आवर्स को ज्यादा नहीं जाऊंगा. आप 4 दिन काम लो, 12 घंटा में स्प्रेड ओवर आवर्स को इंटरप्रेट करो, 4 दिन लो, 48 आवर्स करो, 2 दिन वीकली ऑफ दो. कोई मना है? प्रेजेंट लॉ क्या बोलता है? इफ इट्स 48 more than 48 hours, then question of OT comes. If same day, more than 48 hours, when you are taking his service for 49th hour, 50th hour, for 51, 52, question of OT comes. Not giving, question of exploitation comes. Not giving a substitute holiday, question of comes. Not giving a substitute with the 10th day. You have to give. People arrange rosters. Do it without paying anything. Private sector, they exploit like anything. I worked in state government for about 8-9 years. I have seen mass exploitation like anything. Only manipulation records. Only. But now things are more transparent. The moment you upload your register, it will be visible. It's like faceless assessment in IT these days. Government is encouraging. It will like faceless assessment by us in future. We will hit your lane. We will see. The LO before goes inspection, first study your profile. See everything. He will go prepared. He will mark the gray areas, then he will go. Then when he goes for inspection, then in online he will give in the IR. In online, he will give the compliance. And online, I am the authority, I will see it, I will give verification. Verification means, though there are some minor mistakes you have rectified. So the file is closed with the verification. Yes. Notice board nahi tha. अंग्रेजी लैंग्वेज बंगाली लैंग्वेज नहीं था, हो गया. मेजर irregularity है, then I'll give prosecution, and it will be all on wall. So you have to be highly computer literate, and sometimes you yourself have to be part of IR team. Thank you. Any questions?
Yeah, Dr. Sabat, I think you can invite
Mr. Mishra and Dr. Panda and Dr. Mishra, we have got a few questions in the chat box. But before that, since we have a former CMD of Garden Reach Shipbuilding, Admiral Varma, you have any questions?
Thank you, Saugat. I do not have any question as such, but if you allow me a couple of minutes, I can make some observation.
Okay. In the meantime, in the chat box, we have received from Mr. Shovik Majumdar, will business gear up for these changes in the labor code? How soon? Number one. And how the new labor code will impact employees, working hours, salary,
PF.
Yeah, PF contribution, etc. So these are the two
I think
questions.
salary structure, working hours, and the PF. I think we already discussed those things.
Yeah, that you have already discussed.
And only thing is what he's asking, how the companies are prepared to gear up to accept all these changes.
Right.
That's what exactly Dr. Panda said. It will take time.
It will take time.
I have time and again, I have talked about industrial preparedness to meet the challenges. I have highlighted, I think, many areas of challenges and the problems which you will face, which we are facing, which you are not facing, which you will be facing. You have got now clarity. I have already told many things because I have got a strong bimari for researching on level of last 30 years. So these are the things, many things have been simplified, but many things are newly added upon, which you have to know. As I told, many areas of evidence, for information I may add. Previously, the onus of maintaining evidence, the law was by and large silent. No law had prescribed the onus of evidence, maintenance of onus of evidence. The courts were also in contradiction on their opinion. Many times the courts will say the employee will submit the evidence to make a claim. But the new code, you will find the employer will have onus of providing evidence, which is a very important new dimension. Employer will, suppose there is a complaint, employer will defend with the evidence. This was not there in previously. This was that employee used to be asked, हम लोग क्या करते थे जब ऑफिस में बैठते हैं, हम दोनों को बोलते थे तुम्हारा पास क्या सबूत है, तुम यू आर फाइलिंग ए केस ऑफ टर्मिनेशन or you are filing said I have worked for consecutively for 5 years, so you are claiming gratuity. What evidences you had? So he used to show some evidences, जैसे कोर्ट में होता है विथ प्रिलिमिनरी एविडेंस, आगे की चार्जशीट के लिए इन्वेस्टिगेशन में रास्ता बनता है, तो प्रिलिमिनरी एविडेंस में जब एडजुडिकेशन आगे आगे बढ़ता है, then all the factors come to the knowledge of the authority and he used to pass orders. But now the employer is the onus, the liability will be there
Employer.
to prove innocence. So that is a very important area, that I have not committed any irregularities. This is now your lookout. Suppose person बदली वर्कर आया है, उसी दिन एक्सीडेंट हो गया, वो बदली वर्कर भगवान ना करे फैटल एक्सीडेंट हो गया, मेजर उसका चॉपअप हुआ है, अंग कट गया, he was major disabled. Now question comes whether he is on record or not. One, who will pay the liability? Who will reimburse? Who will give the insurance? Who will take the medical? So these are the areas which you have to now remain alert. And that is what I am saying. Even the Badli, if it is there in the role with biometrics on, then you have got a full contract with your contractor and vendor. Then you can immediately say that ye hai. Then question of negotiation will come, payment, additional amount comes, many things will come there. Because sometimes the negotiation and collective bargaining is beyond the labor law. Sometimes it is about your networking, your common sense, your goodwill, your bhaichara, your affiliations, your so many things are there. But groundwork is basic law has to be right and foolproof. Thank you.
Yeah, adding up what Dr. Panda said regarding the how the business is going geared up to face the challenges, I would just say it won't be that tough for the business to gear up. But the problem what I'm seeing is the unorganized sector, or maybe the plantation sector, like what government is doing now with the new code. They are going to cover everybody. So when we are going to the remote areas, why remote areas? Even in Kolkata also. So if you are going to handle the unorganized workmen, those are working in different setups, maybe a small shop somewhere or a big house where many people are employed. So all those return filing, like, so say there are 20 people working, or maybe as per the limit. So the GST, people have not come back onto the track till date, if you ask me. Because when I talk to people, people still say that अरे कहाँ सिर पे डाल दिया लाके GST, वो return file करो, फिर 3 महीने में और कुछ करो, वो हो नहीं पा रहा है. So I think if government can come up with certain smooth processes where you pay, there has to be something online, automatically takes care. So you don't have to do in return filing, you don't have to engage yourself in doing certain things.
Yeah, that is why return is very simple. Return, I think out of 9, present 5 level of you have got a single return. Return is not a very important. Even the online, if you the moment you will generate the lane, you can simply write in one page about number of employees and tentative mandates and
Unorganized. I'm saying unorganized.
Yeah, same thing will happen. Same thing will happen. It's not a very difficult thing. What only thing, what I am telling in many things, less than 5, less than 1, very small sector, even domestic, I think is exempted somewhere. I have read it. Record register domestic is existing law, it is exempted. So there are many things there exemptions, but by and large, particularly the rig, the platform, the gig, the Ola, the delivery, the Swiggy, the Zomato, their service conditions are going to be big challenges. They are going to be who is their employer, who is the paymaster, what is the interpretation of law, what is the social security, who will pay, if he meets with an accident while going to deliver a food packet for Zomato, we meets with an accident. That is in course of out of employment, and who will establishment, where is insured, who is looking after that, who is looking after that, and that is how those are the particularly these people are of very, very vulnerability for protection and not protection. These are easily all multinational houses now, big companies, they are saying we'll keep track of everybody who is on our roll directly or indirectly. They are making the system very compliant.
Yeah, coming back to the 12 hours working, I just would like to also add up here. When I was with Tata Steel, so that was the time Tata Steel was working 6 days a week. And when I suggested that we should go ahead with 5 days a week implementation, there lots of hues and cry. They said, in a steel company, how can you work for 5 days? And how you will be asking people to work 5 days and whatever the 48 hours duration in a week. But the way the initial issues were there, we got entangled with those issues. But when we went ahead and implemented that, people started coming for 9 hours, 9.5 hours per day, and in 5 days, 48 hours working, and things are pretty smooth. And even in outside countries also, where I've worked in 12 hours working condition also, where people work for 4 days. In Australia, some mining companies, I've worked in some Netherlands and some other companies also, where people come, and those days, I'm talking of the 10 years before, those 12 hours working was very much there, and people are quite comfortable. So there used to be hostels. It used to be like a 5-star hostel. People come there, stay in the hostel, work 12 hours, come back like your offshore projects. When people work for 12 hours, come and take rest for 12 hours. So people come to a mining location, work for 12 hours, and work for 4 days. They can go back, or work for 15 days, and they go take 15 days leave and go home and stay with their family in a nearby city. So all those things were happening earlier before in countries outside India, and we have done many such things in India also. And this is not a big thing. We can do it. And only thing is how the implementation part is going to be taken care by the company with the support of the union, the trade union, those are working there. And because there is a problem, we say that we don't accept change in a very positive manner. Because whenever there is a change, we always try to form a wall in front of us. We think that the change is coming to destroy us, but we don't really decide. We don't really think about it. We don't really analyze how the change is going to create some good things for us. I think that is the way we have to take this particular code, which has come into picture now. I think Dr. Panda can tell us how many more days it would take for the implementation of.
I'm not the right person to answer. I'm not the right person to answer.
Okay.
Our ministry is ready. We are ready. We are waiting, in fact, and we don't have a correct picture what is happening in decision-making forum at the top.
Right.
But yes, this has got industry has to remain prepared. Actually, students who are reading in colleges, also the practicing, also the grassroots, everywhere they should know, they should remain prepared. Actually, many of the case laws which have led a way to reforming these labor codes have not been actually discussed in the past. That is how we are facing problem in knowing the code. Otherwise, many case laws have been integrated while framing this labor code. Only there are some areas like where it needs little bit of negotiation, and I think government is aware of certain areas, and they are very much a lot they are discussing. But yes, service sector for me the biggest challenge is for service sector because of many of the things are new to them. Like industrial standing order will be applicable to them, but there it is 300. But standing order is a very useful document for controlling the workers from point of maintaining discipline in industry. It is like Bible of any person to maintain discipline. And they have raised the number of workmen selling there, workers selling there. But most importantly, they have removed they have made the industrial establishment simple. That is how it will be applicable to all sectors. And you should not think of 300. Even if you have got 30 people, standing order, the model standing order may be applicable to less than 200. So you may make it as a part of your agreement document, extended document of your agreement, so that at least the Indian Contract Act is valid 1-to-1. And when you have got a, suppose, a contract with the contractor, we have got a circular in 2019 where whenever CLC has given a contractor, when you are making tender document when is advertised by the employer, they are not keeping many things abreast in the public domain. So that is how it is leading to a lot of confusion at the time of implementation. 1, 2, even after the contract is awarded, the contract agreement also many times does not keep many finer points of law. So when at the time of disengagement, they are going to face fraud. Now you see the commencement completion were there previously. Now completion is now linked to the terminal benefit. It's very interesting stress area. Second, there is another provision in, I think, the Wage Code. If you find section 44, the new, if the worker dies or vanishes, absconds, the wage liability have to be deposited with the controlling, with the authority. This was not there beforehand. This was not there. Section 3(2) PW Act has been amended in 2005. Fine. But now they have incorporated liability in clearly what you have to do in case of death on an employee whose dues are payable by you. How to discharge your liability is a new section. 55(3) is there. Now 55(3) is linked to your discharge of security. Previously, the security deposit was very less, 90 rupees. Now security deposit will be a very big amount. It can be discharged in case of non-payment. So how to keep that security at your level to avoid 55(3) liability? Thank you.
One more thing from my side. Now the compulsory notification of vacancies. I think the new code, it's also speaking something about it. And secondly,
I think Supreme Court has very clearly made it rather nullified. I think Supreme Court in passing judgment, they said it is more important to be in public domain than to follow the compulsory vacancy notifications act.
Yes.
So public domain is more important.
Yeah.
How you are going to give and make transparency, bringing into public domain. Agar aap 10 paper mein de rahe ho, that is more important. Employee Vacancy Notifications Act were misused by many forum, many people are deprived. So Supreme Court has done away with it.
Yeah.
Thank you.
So
I've got some official work. I'll take leave. Mr.
No, just a minute, Dr. Panda and Mr. Pathasarthi. Also, we have Mr. Tushar Basu, our chairman of HR Council. He would like to propose a formal vote of thanks before we.
I was in Calcutta. Only 2 days back I have joined here. I was
I know, yes, sir.
We never met in 4 years. But I have addressed your CI Eastern Zone and CI Calcutta. I have addressed NIPM. I have addressed because sometimes when I'm free, I used to go and address. That is another issue.
I know, but now I'm in MCCI.
That is what I could see the visibility today.
Yes. So, Mr. Basu, over to you.
Thank you. Members, guests, ladies and gentlemen, we had a very engrossing session on new labor code today. It is indeed a proud privilege for me to propose a formal vote of thanks. Our sincere thanks to Dr. Tapos K. Panda, CLS, Welfare Commissioner, Government of India, Bhubaneswar, and former Deputy Chief Labour Commissioner, Central, Kolkata. Sir, we thank you for your views and perspectives on this very important area of new labor codes. We thank Sri Parthasarathi Mishra, board member of Amne Corporation US and former CHRM Tata Steel OMQ, that is O Mines and Quarry Division, for sharing his thoughts and knowledge on new labor codes today. Dr. Pandey and Sri Mishra, we thank you for sparing your valuable time and addressing us. I convey our sincere thanks to the distinguished guests and members for their presence and participation today. MCI session on demystifying new labor codes is indeed a very timely and topical. The revised provisions under the 4 new labor codes dealing with wages, social security, industrial relations, and occupational safety are expected to cause enormous impact on both the organizations and their workforce. We all need to comprehend the impacts of this new labor code and what measures we need to take to align our practices going forward. Today's session is an initiative in that direction. We would love to hold similar sessions for the benefit of our members going forward. Sri Mishra and Dr. Panda, we would look forward to your continued support and guidance in terms of any further clarifications that our members may need in the future. With these few words, I propose a warm and hearty vote of thanks and request you all to carry it with acclamation. Thank you.
Thank you, sir. Thank you. Thank you so much.
Thank you.
Thank you very much.
Thank
Thank
you.
you,
Thank
you.
NCCI.
Thank you.
Thank you. Thank you so much.